Welcome back to our broadcast of the 14th edition of the annual conference of the Nigerian Bar Association section on business law. We're moving on to a very interesting part of today's program. It is a debate session, and I will simply just introduce the moderators and be out of your way as we allow them to engage the debaters. So please welcome Olutosin Iyayi from Alukwano Ibode and Damilola Wright from Banwo and Ighodalo.
Hello, everyone.
Good afternoon.
Good afternoon. I am Damilola Wright, and I am delighted to be co-moderating this debate session tagged The Next Normal, Practice in a Borderless Legal Profession. We're very thrilled to have you here because this is arguably the highlight of the entire conference, and we trust that you're going to have an enriching and enlightening time with us today. Before we introduce the debaters and the debate rules, we would like to introduce the debate topics. There are 4 topics up for debate today. The first topic is digital technology an aid or inhibitor to legal practice? Now, to my mind, I would say it's an aid because, the past couple of months, we have been working from home thanks to technology. But Tosin, do you have any thoughts on this?
I have a contrary opinion that.
Okay.
And the reason is because, in as much as everyone has been trying to work from home, it's been a nightmare. So, really, digital technology has actually been more of an inhibitor than an aid. A lot of people are not able to meet their deadlines, their targets, because of all the glitches that technology presents. But we'll leave it for the debaters.
Okay, let's see what the debaters come up with.
And of course, you'll decide ultimately.
Of course, the audience will decide. The second topic up for debate is, are 9-to-5 work patterns still relevant? This should be interesting. I believe that really and truly, the work from home thing might be a scam, and so people might argue that 9-to-5 work patterns are still relevant. But let's see what the audience thinks and the debaters say. Tosin, any thoughts?
I think that 9-to-5 patterns are no longer relevant. I think that the world has moved. You can get into a meeting at 7 a.m., 8 a.m. You don't have to worry about trying to get through traffic or trying to do certain things for heading out to a meeting. And really, there's really no resumption time, there's no closing time. You can do your work up until midnight. You don't have to worry about being in the office late. So honestly, I think that right now, the world has moved into the flexi situation. 9-to-5 patterns are no longer relevant. But again, you decide. The debaters will speak about it and then you'll decide.
Alrighty, okay. Let's go to the third topic. The third topic up for debate is, are Nigerian trained lawyers well equipped to practice in the digital age? This topic is pretty interesting, and I know that we have a lot of legal challenges to our legal system and legal education, but I would argue that Nigerian trained lawyers are actually well equipped to function in this new economy. But do you think differently, Tosin?
I think very differently. And I'll tell you why. Recently, I heard about the fact that people in secondary school, students in secondary school, are still being taught how to use typewriters. There are typewriters that no longer in use. They become obsolete. And we're talking about the digital age. We're talking about moving to the next level.
Well, fair enough.
So who uses typewriters? And if you're training people for the next level, why would they be using typewriters? So I think that Nigerian lawyers are not equipped enough. We're still arguing about the constitutionality or otherwise of virtual court hearings. I don't think we're ready.
Okay, let's hear what the debaters have to say. And the final topic up for debate is pay cuts in a COVID-19 era, a necessary evil or an unfair burden on already underpaid lawyers. Now, this is a bit tough because when I think about it, COVID-19 has been really hard on everyone. And I think sacrifices are being made by all, but again, it's a bit tricky. So, Tosin, would you say that it's unfair?
I think it's so unfair. Lawyers are already underpaid compared to their contemporaries in other industries. Everyone wants to run away from working in practice and going to do something else, make more money. And then on top of that, you then reduce pay, you cut pay. I don't think it's fair. I think it's a very unfair burden. But we'll hear from the debaters and then you all decide at the end of the day because there'll be polls and you'll be allowed to vote.
Okay, just on polls and allowing to vote, do you want to walk us through the debate rules as well?
Yes, so I'll just run through the debate rules real quick. So we have 4 topics. Each topic last for 15 minutes. The speaker for will go for 5 minutes, and the speaker against will go for 5 minutes. Then each side will be entitled to a 2-minute rebuttal. So the speaker for will go for 2 minutes, and the speaker against will also be entitled to go for another 2 minutes. Now the last minute will be for the voting on the polls, and then that topic will close. At the end of all the 4 topics, we'll come and announce the results.
Okay, fantastic. And so we'll go right into it, and we'll begin by speaking about the topics and introducing the speakers. We will start with the first topic and the first set of speakers, and then we'll allow them speak. And then we'll come back, introduce the next topic and the speakers, and take it like that. And so the first topic, like we said, is digital technology an aid or inhibitor to legal practice? For the motion is Omomi Fatogo. She's an associate in the Communications and Technology Practice Group of Adeniyi Kazeem & Co. And the speakers, and take it like that. So the first topic, like we said, is digital technology an aid or inhibitor to legal practice? For the motion is Omomi Fatogo. She's an associate in the Communications and Technology Practice Group of Adeniyi Kazeem & Co. And the speakers, and take it like that. So the first topic, like we said, is digital
ready. And he's ready to convince you all that digital aid is indeed an inhibitor. So sit back and enjoy.
All right, over to you guys.
Omomi and Charles, you have
speakers, and take it like that. So the first topic, like we said, is digital
ready. And he's ready to convince you all that digital aid is indeed an inhibitor. So sit back and enjoy.
Thank you,
moderators.
Over
to you guys.
Omomi and Charles,
permit me to stand on the existing protocol.
Speakers, and take
in
it
the
like
words
that.
Of Honorable
so
Justice
the first
Kashim
topic,
Zana,
like we said, is
Chief Judge
ready.
of Borno State.
And he's ready to
Our legal
convince
marketplace
you
of
all
tomorrow cannot be immune
digital
from
aid is
the
indeed an
technology that
inhibitor.
permeates
So
its
sit
socio-economic
back and
fabric.
enjoy.
Thank
All
you,
right,
moderators.
over to you guys.
Omomi and Charles, you have
Petitioner stand on the
would soon be
existing
as
protocol.
extinct as speakers, and
In
take
the
it like
words
that.
of Honorable
So the
Justice
first
Kashim
topic,
Zana,
like we said, is
Chief Judge of
digital.
Borno State.
And he's ready to
Our legal
convince you
marketplace of
all
tomorrow cannot be immune
digital
from
aid is
the
indeed an
technology that
inhibitor.
permeates
As we all
its
know,
sit back and
fabric.
enjoy.
Thank
All
you,
right, over
moderators.
to you guys.
Omomi and Charles, you
Every
have
stand on the
would soon be as
existing
extinct
protocol.
as speakers,
For
and take
every
it like
words
that.
of Honorable
So the first topic, like we said, is digital.
and he's ready to convince you all
tomorrow cannot provide
digital aid is indeed an inhibitor.
As we all know,
So sit back and enjoy.
Thank
All
you,
right, over
moderators.
to you guys.
Omomi and Charles, you
Every
have
stand on the existing protocol.
Speakers,
For
and take
every
it like
words
that.
of Honorable
So the first topic, like we said, is digital.
Nowadays, thanks to the quintessential development of Law Pavilion, of Ligopedia, Westlaw, LexisNexis, and so many other research sites, Law Pavilion on its own boasts of more than 9,000 ebooks covering case reports from 1970 till date. It has a law digest of more than 40,000 issues covering several areas of law. And we also have a 48-hour automatic case report system, amongst other features. This research site has greatly reduced our research time as lawyers and has also reduced our need for space. Let us imagine a world without Zoom. Let us imagine a world without Microsoft Teams and other virtual communication tools. We would have been long out of business. Nowadays, we can sit in the corners of our homes, our offices, and conduct client interviews. We can clinch briefs, irrespective of where our client is located. The recent lockdown caused by the COVID-19 pandemic saw so many law firms laying off staff because they were no longer able to service their clients. However, non-traditional law firms like Adeniyi Kazeem & Co. were able to prefer non-litigation services to their clients, irrespective, even though they were working from home. Let us also take a look at a fully virtual law firm like Fisher Burrows that has more than 100 partners in more than 20 countries of the world. In 2019 alone, they raked in a revenue of more than $91.6 million. This has shown that we do not even need a lot to start or run a legal practice in Nigeria, especially. Now, in a country like ours, where as lawyers we are expressly prohibited by our rules of professional conduct from advertising or soliciting before we can clinch briefs, how are we able to expand our client base? This is very simple. We are only able, we can maintain a website and ensure that we write articles that provide solutions to common legal issues that an average man faces. This, in turn, has given visibility to many law firms and has also given us a platform to showcase our services and attract prospective clients from all over the world. You would agree with me as lawyers that in recent times, we've been able to interact with many government agencies quite easily because many of them have gone paperless. A good example is the Corporate Affairs Commission. Nowadays, instead of going there physically, we can make our transactions online, we can make our payments online, and also make our applications online. This has enhanced our delivery and made us more efficient, while also reducing physical interactions greatly. My colleague on the other side might want to unnecessarily stress on the issue of bad network in Nigeria. However, I would like to remind him that in Kenya, between the months of March and April 2020, they were able to deliver more than 89 judgments via Skype. They've streamed this on Facebook Live, and they also updated their website with this same judgment within 48 hours of their delivery. I'm also very pleased to say that a country like South Korea has a very advanced court technological system, which took them a painstaking 30 years to achieve. I believe that our Nigerian judiciary can achieve this same feat if only we are ready to think long term and also embrace the initial challenges that we are bound to face with digital technology. Our legal profession is quite known for being quite archaic, and we are known for sticking to long-standing traditions. However, okay.
All right, permit me to stand on the existing protocol. I'm here to speak against the notion that technology is an aid of legal practice. There has been so much fuss about technology being an aid of legal practice, but I'm here to state clearly that this is not true. To a large extent, technology is an inhibitor of legal practice. Legal scholars have written extensively on this issue, and they've spoken extensively on the need to exercise caution while using technology during legal practice. I'll move on quickly to the 4 reasons why technology is an inhibitor of the legal profession. First issue is the security of information and data. We all know that data breach is a very prevalent occurrence across all digital platforms, across all technological platforms. The legal profession is such that thrives on the principle of confidentiality and is hinged heavily on the privacy of information and data. What this means is, with a simple data breach, sensitive and private information can end up in the wrong hands. This is clearly not the kind of legal profession we want. This is clearly showing that technology is not helping the legal profession. Secondly, with the increased use of technology comes the possibility of requiring less manpower. When machines are deployed to do tasks that lawyers would have otherwise been assigned, what this is causing is the possibility of unemployment being legalized. This is clearly not helping the legal profession. Thirdly, in reality, technology can only produce what it has been programmed for. A machine can only deliver what has been programmed into it. So let's take, for instance, where a machine is programmed to review, say, corporate law documents, and within the document, it sees elements of taxation or real property. It runs into a problem because it was not programmed to review that particular aspect of law. So what you will get eventually is you will get machines producing work that are below the required standard. And machines cannot really cope with the dynamism of the legal profession, which only human intelligence is well capable of handling. So what you get now is machines to produce results that are below the required standard. So there is a great reduction, or there will be a great reduction in the qualitative and ethical standards that the legal profession is highly reputed for. How then can we not say that technology is an inhibitor of the legal profession? More importantly, with technology comes accessibility of information. What this means is that clients that are tech savvy can have access to information online, when they can have access to excellent services, legal services online, why then would they need to brief lawyers? Why then would they need to brief law firms? So the pricing pressure technology will bring within the legal practice is a very important factor. Therefore, technology is not helping the legal profession in any way at all. Because if lawyers can't get degrees from clients who are tech savvy because they can easily access this information online, then technology is not really helping the profession. What is an inhibitor, if not something that stops or slows down the process? From all the reasons given, I am here to say clearly, evidently, and doubtlessly that technology is an inhibitor of the legal profession. Thank you.
I am quite surprised by some of the arguments marshaled by my opponents in his submission. May I remind you that the reason why we are here today, why we can have an e-conference and even have this debate in the first place, is because in the face of COVID-19 pandemic, there was no other we were not even presented with so many other options apart from canceling this meeting or having an e-conference. And it was against the backdrop of technology that we're able to convene people from all over the world to enjoy some of the insightful conversations we've had since yesterday. So many of you are out there, cuddled up, carrying out your daily activities, and generally just enjoying bonding with your family, while also diligently following the conversations on this platform. Why would you want to sacrifice this convenience on the altar of sentiment? Why would you want to do that? Many thanks to some of the internet service providers that we have now. So many data bundles are available for very, very affordable rates. Some of them are even free if you are a loyal customer. On this note, there is no excuse for any lawyer not to make efforts to make sure that they keep learning and getting better for their clients' satisfaction. On this note, I would like to end by saying that I would rather be seen grappling with the challenges of digital technology instead of being stuck with the manual way of legal practice, which is only akin to living in the Stone Age. Thank you.
I'm really surprised that my colleague is hinging an argument on this conference. The reality is the legal profession is not just a profession, it's a business. So you can't just look at the conference as one side of it. The legal profession, I'll give a very real example now. Corporate Affairs Commission has now moved the services online. So corporations and all other transactions are now done online. What this means is that with this online platform, people can register companies, do all their corporate work without necessarily involving lawyers. Now, the statutory declaration that used to be like a reason for people to go to lawyers can now be waived. Corporate affairs work is one of the most important, I would say, to lawyers, especially junior lawyers. So if you are now putting everything online, that people can now register companies without necessarily involving lawyers, you are taking a substantial part of the business aspect of the legal profession away from the practice. So how then can we say technology is helping the legal profession? It's a business, not just a profession. Legal profession is not all about conferences. It's a business. So if anything will take away the business aspect of it, take away the profitability of the profession, then I can say clearly that it's an inhibitor of the legal profession. To add to this, US consulting agency McKinsey did a research and they came up with figures that if we continue to use technology within the legal profession, there is a chance that 22% of lawyers' jobs will be at risk, and 35% of legal clerks' work will be at risk. So what this means is that technology is out to take lawyers away from business. So how can we, in good conscience, say technology is helping legal practice? I would say clearly that technology is out as an inhibitor of the legal profession. Thank you.
I guess that while the audience is also voting, we could also introduce the next topic and the speakers.
Yes.
Okay, so the next topic is, are 9-to-5 work patterns still relevant? For the motion is Abolanle Ayola. She's an associate in the corporate practice of Odunjiri and Ifulu. and she'll be arguing for this motion. I know she's going to really do well to persuade you guys that 9-to-5 work patterns are still relevant.
And speaking against that motion is Robinson Mweye. He's an associate in the law firm of Marcus Okoko and Co. in the commercial practice. Now, Marcus is going to try to speak against that. So, you both have 15 minutes, 5 minutes to go, 5 minutes, and then 2 minutes rebuttal each.
Thank you, moderators. I humbly stand on existing protocols. To correct something first before going ahead, I'm actually speaking in support of that notion that the 9-to-5 work hours are still very relevant in our workspace today. With the outbreak of the COVID-19 pandemic, which has led to various restrictions and government lockdown, businesses and corporate entities have been forced to start working remotely and mostly from home. Of course, it has also led to innovations such as the use of virtual platforms to host meetings and business negotiations. So the question now arises if the 9-to-5 work pattern is still relevant or has become obsolete. As a transactional lawyer, it is my firm view that the 9-to-5 work pattern is still very relevant and should continue. First of all, how did the 9-to-5 work pattern came about? It was initiated by the Ford Motor Company in the early 20th centuries for the workers, and it's actually a concept introduced by Robert Owens, a labor leader, which argued for 8 hours of work, 8 hours of recreation, stroke personal development, and 8 hours of rest. It is very important for an organization to be able to balance between work and time for rest, stroke personal development, especially for its employees. My first point on the need for the 9-to-5 work pattern to continue, and the fact that it's very important, is one, it helps to balance work life and your personal aspirations, stroke fulfillment. The goal of every profit-oriented organization, of course, is to make profits and to maximize productivity. They do this by engaging skilled workforce to be able to meet their goals and aspirations. Of course, these members of the workforce of the organization also have their personal aspirations through goals. Of course, it has to be in line with that of the organization they are working for as well. It is, however, very necessary and important that the 9-to-5 work pattern is maintained so as to allow a me time for the employees so they can have the time to do their personal research, register for courses online, of course, with the technology we have in place now that you can run programs online, you can run your masters online and all that. They need that time for themselves as well. As they gain knowledge, more experience and understanding, of course, they'll bring that to bear in their organization, which will also help the organization to achieve its goals and aspirations. Secondly, the 9-to-5 work pattern also creates room for teamwork and collaboration as opposed to unnecessary distractions and isolation. Because if you're working from 9 to 5 and in your office space, you get to interact with your colleagues, you get to interact with members of your team, especially when you're working on a particular project. When you don't, sometimes you might come across some difficulties or some things you don't understand. You can easily reach out to your colleagues who might just be on the next seats or in the next office. You can easily reach out to them, ask for some explanation, ask for some help. Even after you go to you make a document, maybe an agreement, a JVA also, you can ask your colleague to help you briefly review so that you can send it in no time, because you just take your system to your colleague here and then, and your colleague goes through it, help you review the document and send it back to you, and you can forward it. So another point is that it also promotes productivity, because when you're in your workspace between the 9 to 5 working hours, of course, in your office, it gives you time, like you fully concentrate. You don't have unnecessary distractions, as opposed to maybe when you're in your house, family, friends, somebody. So long as they know you are home, they don't necessarily think that you're working and they can barge in at any point in time and disturb your workflow. But if you're actually working from 9 to 5, it is on paper. You're focused on that time, and after the 9 to 5 period, you have time to maybe socially interact and all that. Another point is that the 9 to 5 work time actually creates this corporate feel. I've met some friends, some friends that are, say for example now, I was employed in a law firm during this, or say after this, the easing down of the COVID. I'm employed in a law firm and I have to be working from home continually. Sometimes my neighbors will begin to wonder, that's a young man, does he even have a job? He's always indoors. They don't know that I'm inside pressing computer. They start wondering, does he even have a job? He's a jobless person. But if I'm working from 9 to 5 and I have to leave my house before 9 a.m., you see me put on my suit and everything and knot my tie and start working out. Sometimes they even start hailing you, the law, the law. You don't get all that.
Thank you, Robinson, for those points which you were able to deliver clearly from the comfort of your home. And to the audience, I'm sure we're all happy to be attending the conference free of charge from the comfort of our homes and in comfortable clothes. Now, straight to the point. Work pattern and working flexible hours was a luxury only some people enjoyed. Why that was the case, I don't know. For something that benefits both the employer and the employee. But thanks to the pandemic, all of that has changed. Now, I'd like to start by saying the 9 to 5 was created during a completely different era, a completely different time, not the time in which we live in now, where there's the advent of technology, there's globalization, international clients, cross-border transactions, and partnerships between local and international law firms. Talking about technology, with the advent of technology, flexible hours and working remotely is now considered attractive, efficient, and cost-effective for both employers and employees. We have laptops that allow us to work remotely. We have Zoom, Microsoft Teams. We digitize our documents, and we have, this hopping that has made it possible for people who have never attended this conference to be attending the conference. And for employers, this doesn't only benefit us, it benefits you as well. You can cut overhead and operational cost. You can get a smaller space and pay less on rent, pay less electricity, internet, and some other bills. This is a period in which we're all complaining about the, significant effects of the pandemic on our income, and you want to cut costs. This is a way to cut costs, not costing the salary of some lawyers who are already underpaid. I mean, to be honest, like for us girls, this baby girl lifestyle is not going to pay for itself. And I mean, in all fairness, like we all have bills to pay. That's the honest truth. Now, moving on from that, we talk about regulatory engagement. As we can see, prior to the pandemic and even during the lockdown, a lot of regulators are migrating their activities online. CSC, SEC, FIRS, this is all happening. Electronic signatures are now accepted for executing transaction documents and agreements. The Supreme Court has held that remote hearing is not unconstitutional. You see that even restricted areas of law that we would be concerned about, all just trying to make life easier for each other. Now, talking about productivity, how many people actually work, fully the 8 hours or 9 hours from 8 a.m. to 5:30 p.m.? Nobody does that. Research has shown that on average, people only work 2 hours, 53 minutes within the 8 hours. And people who work from home raise their productivity at 7.7 out of 10, as against people who work physically in the office, who rate it as 6.5 out of 10. I mean, because they're not distracted by things like office politics and, a whole bunch of office mechanics that they have no business with. They focus on their task and they move on. Now, talking about, how we're only working 2 hours, 53 minutes out of the 8 hours, traffic. We all know traffic in Nigeria is horrendous. I mean, you enter traffic 2 hours in the morning. As you're going home in the evening, another 2 hours. That's 4 hours that you have wasted in traffic. Multiply this by 5 working days in a week. That's 20 hours. I mean, if you multiply that by 20 working days in a month, do the math. That's time that you can put towards, improving your legal skills. You can take training, you can take courses, you can write articles. I mean, in this period where we need our lawyers to be well-versed, employers, do you not want to have well-rounded lawyers? Talking about employers, you see that with this working from home situation, you have access to a wider pool of people to recruit from that you would otherwise have had a chance to recruit from. There are people who maybe for family reasons or health reasons might not be able to come to Lagos, the commercial hub, for you to employ them. But with remote working and flexible working, you have access to them. You don't have to restrict yourself to someone that you otherwise you wouldn't have. All right, thank you. Thank you.
Okay, thank you, Tosin. Firstly, I would like to draw the attention of my colleague that we're not actually arguing in reality about remote working or no remote working. What we're actually arguing about is the time, 9 to 5. Is it still relevant or not? Despite the fact that I might be working from my office or I might be working from home, am I supposed to stick to the 9 to 5 pattern, or I can work flexibly, like do a work by 10 p.m., 11 p.m., 12 p.m., and all that? And talking about regulatory agencies, I wonder if I'm to do a transaction, I'm working on a major transaction now, how do I interface with SEC if I say I'm at my house, pressing my computer and all that? The reality on ground is that in Nigeria, most of the regulatory agencies are yet to be digitalized, except of course for the Corporate Affairs Commission, which is trying very much in that regard. Though they still don't accept electronic signatures. You must sign the document with a pen and take to them. So I believe that the 9 to 5 work hours is still very relevant and should be maintained to allow the employees to have the right mental strength to continue in their work and deliver efficiently. Thank you.
So I will respond to your initial points. Initially, you spoke about work-life balance. Now that when you're in the office, you work late hours, would you not rather work those hours in the comfort of your home where you can multitask and do a whole bunch of things? Like, I would rather work, the hours that I work on a normal day from the comfort of my home. It makes me comfortable. Maybe you prefer to stay in the office till late, but that doesn't work for me. You spoke about teamwork, that how you're able to have a relationship with your colleagues because you're physically in the office. Now, let me tell you this, my supervisors are not physically present in Lagos, but our work moves like conveyor belt, and we have an amazing relationship. Now, you spoke about distraction. I feel like all that office politics, office mechanics, all of that is a major distraction to people. When you work from home, you're able to focus on the task for which you're being paid. And, for me, and then you spoke about regulatory earlier sessions. There are people who had spoken about how they're now using electronic signature and they're also making filings with regulators. And I do agree with you. Yes, they may not be fully online yet, but if, for example, I do FIRS visits, I wake up in the morning, do what I need to do, go to FIRS, make the filings that I need to, or the documents that I need to submit for stamping. I come back home and I continue my work. So say 9 to 5 patterns is not relevant. We don't necessarily mean sitting at home, not leaving your house, sitting at home and doing the work. It's working flexible hours. It's, working from home. So we're not saying, because they're not all online, that you should be confined to the 4 walls of your office. That's not what we're talking about. Thank you.
Okay, that was a very fiery session. Abundantly, your time is up. Now we're going into the third debate.
No, the polls. Please get voting. Are 9 to 5 work patterns relevant, or have they become irrelevant? You decide. You've heard them. So get voting. Just head over to the polls and vote.
That was actually a very interesting one, actually.
Very interesting, and it's actually interesting to find out what the polls will say.
Yeah.
I think I have my guesses, but
I do too.
we'll wait.
All
Okay,
right.
so the
third
next one,
debate
yeah.
topic is, are Nigerian trained lawyers well equipped to practice in the digital age? For the motion is Chukwudi Ofili. Chukwudi is my guy, so I'm a bit biased about this one. He's an associate partner at Detail Commercial Solicitors, and I know that he's here to convince you and persuade you guys that indeed Nigerian trained lawyers are well equipped to compete with their counterparts all over the world.
Tolanilai Babatunde, an associate at Copley Partners, will be speaking against, and I have no doubts in my mind that she's going to do justice to this topic. So guys, you have the floor. Chukwudi.
Go ahead.
Good afternoon, everyone. My name is Chukwudi Ofili, and I'll be discussing the following points which show that Nigerian lawyers are well equipped. Law firms now provide a technology-friendly environment for the practice of law. A lot of Nigerian lawyers, law firms, and in-house legal departments have invested heavily in technology, both hardware and software. They now use technology to perform routine tasks like legal research, drafting, and review of contracts. Research is now conducted entirely with rigorous and robust training of lawyers, such as both hardware and processing, such as in most cases are accompanied with rigorous massive costs for clients. The second point would be that these tools to practice in the digital age are not as complex as those required by science engines such as Law Pavilion, Practical Lawyers, or tech specialists. It can be argued that it's largely integrated devices such as your mobile phone. You can find your way around using these tech tools to aid the delivery of Zoom, Microsoft Teams, Google Meet, and the other suite of Microsoft applications. The ease with which lawyers use the Hopin platform for e-conference is evidence enough that the fact can find your way around using the view of legal services in the digital age. In addition, lawyers and law firms are more interested today than ever and are utilizing other bespoke legal tech products, legal services in the digital. In addition, lawyers and law firms are more interested today than ever. Agents of tech lawyer firms are beginning to see a lot of lawyers and law firms that understanding algorithms to handle new data sets. You even have lawyers who have a lot of virtual IP and IT law firms. And then we have a lot of lawyers who have even established legal tech startups that offer these products using technology. There are a lot of examples. The fourth point is lawyers who have had to adjust to the new normal in the COVID-19 era. Although most stakeholders in Nigerian technological tools to aid their practice. The first point is the success stories that the COVID-19 era. Although most technological tools to aid their practice in the pandemic has accelerated the intended reports of lawyers being more efficient, meeting deliverables, and being more productive because they do not have to get into 10 hours or 5 hours of traffic every day. So they now use technology to perform tasks seamlessly and without hassles and stress. During the pandemic, lawyers have been able to assist clients and immediately provide much needed information on how to deal with using webinars. And for the litigation lawyers, there's no better testimony that they are well equipped to use digital technology in this. The recent decision of the Supreme Court that virtual hearings are not unconstitutional and thus should be fully well equipped to use the testament to this fact. While it can be argued that the legal education in the country is yet to catch up with the use of technology, there are a number of universities in the country that can boast the use of advanced technology and training lawyers. In addition, lawyers are already taking advantage of various international online from sites like Udemy and Coursera. Recently, we have the Legally Engaged Academy, which has come up to provide legal education that can boast the use of advanced online classes from sites like you provide online legal education for lawyers with modules geared skills required to practice in the digital age. Finally, I would say that while we might be quick to reach a conclusion that Nigerian lawyers are not well equipped to practice law in the digital era, from personal experience, I'm aware that most of the challenges that we face in fully embracing and deploying technological tools in the practice of law are the same challenges that are being faced by lawyers in other jurisdictions. These challenges in themselves do not mean that we are not well equipped. These challenges show that while we are a traditional and somewhat rigid profession, technology is taking the world by storm, and we have no option but to adapt, and evolve along with it. Being well equipped is an ever evolving process and a moving target, a target we must follow very closely. Thank you.
Hello, everybody. All protocols duly observed. I just want to say that Chukwudi just made my points for me, because as we all heard over there, he was breaking up a bit and we couldn't really hear what he was saying. So my topic for debate is, are all Nigerian trained lawyers well equipped for practice in digital age? I will start this argument by saying, what does it take to be well equipped for practice in digital age? The digital transformation of legal advice creates many opportunities, but it also creates stumbling blocks for both new and old lawyers. We have to understand that practice in a profession could mean many things. Spending hours drafting. However, there are three things I would like to quickly touch on why I think we are not well equipped for the digital age. And I know mentioning them to you would make my argument for me. Number one, the Nigerian law school training. Number two, the access to electricity and data. And number four, the mindset of Nigerian trained lawyers, of employers of Nigerian trained lawyers. The syllabus of the Nigerian law school is not fashioned towards meeting the challenges that businesses present and the practice of law that is needed in this modern era. The courses are too localized to meet the requirements of international exposure. And because the challenges that lawyers will be dealing with in the new world, so to speak, is beyond the rudiments of what is being taught now. The Nigerian law school is not providing the basic innovation in its teaching and training of young lawyers with regards to facing a world without borders, even down to the drafting skills of law students. How many Nigerian trained lawyers can truly draft? In the digital age, e-communication is key. Things are being done over mail, and you'll be surprised how many people rely on their ability to speak during a physical meeting than send correspondences over mail, or just being stuck in the old ways of using archaic phrases in their correspondences. The digital age doesn't have time for that, which brings me to mail. The law practice of the digital age needs the lifeline of the digital age, and that lifeline, ladies and gentlemen, is data. The new normal is remote practice over the internet. And to do that, you have to have clean, clear, crisp connection to the World Wide Web. But we here in Nigeria have the unfortunate fate of overpaying for poor, slow, and frankly embarrassing internet. You'll be on a Zoom meeting and somebody has to be holding your SpectraNet modem up in the sky just so you can get to bars. I mean, it's really not our fault, it's what we have. Even just now, Zoom had been hinting me that my network connection is unstable, which brings me to my next point of argument. As we have all experienced during this time of the coronavirus pandemic, a digital practice means having to perform anywhere of your usual space, out of your comfort zone, and mostly in your house. I attended a webinar not long ago, again put together by the SBL. And Mrs. Lola Esson described remote working as anything that allows you to work from anywhere, such that you are able to connect with your critical stakeholders on digital platforms. Are Nigerian trained lawyers equipped for these digital platforms? The answer again is no. One of the cornerstones of the modern age is electricity. And in this part of our world, is something that we are still lacking. In the conventional world that we have been living in prior to being thrown into this pandemic, the burden of providing constant electricity fell on the firm. And it made sense because everyone was all under one roof. But now, remote practice means that there has to be electricity for each member of the team wherever they live. It means that lawyers would have to run their personal generators for much longer than they would have. It means that employers have to provide a way to ensure that essential workers have access to constant electricity and even backup electricity as long as they are out of the office. In fact, I would have loved to ask how many of us during this coronavirus time had told our bosses we didn't have light at home. Now, my opponents will tell you, yes, Nigerian trained lawyers are well equipped for practice in the digital age. But how can we be well equipped if we don't even have light? We all will not grow together at the same pace. And unfortunately, we have learned brothers who practice in different parts of Nigeria. Some parts of the country are left behind with infrastructure, and this makes communication very difficult. It makes it hard to stand up to global practice, and technology is what levels the playing field for us. And during this pandemic, we have even heard of and seen efforts to introduce remote hearing.
Okay. So I understand that I had network issues. So I'll just do a quick rundown of what I said earlier within the 2 minutes. Key points are law firms now provide the technology and friendly environment for the practice of law. The required technological skills are very basic skills and they are quite intuitive. And if you've been exposed to tech devices, you can find your way around using these tools. Like my opponent has tried to use the failings of the Nigerian system to support our argument that Nigerian lawyers are not well equipped. The reality is that these are issues that we are all grappling with. They're not peculiar to law. And like I said, in rounding up my arguments initially, I'm aware that most of these challenges that we face are not challenges that are peculiar to lawyers alone. They're not peculiar to Nigeria alone. Other African countries are grappling with it, but this does not put us in a worse off position than other countries. I dare say that all that we have to do is to evolve and adapt with technology. Being well equipped, like I said, is an ever evolving process. We started it. We are far along in the journey, and it's a moving target, and we have no option but to follow the targets. Thank you.
I would like to remind my opponent that the topic today was that all Nigerian trained lawyers equipped for practice in digital age. The points that he has made, I would argue, are primarily focused in Lagos and Abuja. Most of the people that have access to the tools of the digital age are based in these places. And even then, the statistics show that in these places, there is an unbalance as to the access of necessary infrastructure. I would also like to add that Nigerian employers are not really ready to encourage remote working. We aren't well equipped for the digital age if we still cling to this type of mindset, especially when the reality is we don't have a choice. The world is moving and the pool of workforce that are available wouldn't want the traditional way of doing business. Most people wouldn't want to work for firms who still consider full-time jobs. Employers are too dependent on physical proximity, and there's a fear that employees wouldn't do the work that they are supposed to do, and that employees left to their own devices wouldn't produce the same quality of work, etc. There has been such a set way of practice in Nigeria that I believe that most employers are finding it hard to adapt in the digital age. Are we well equipped? No, but we don't really have a choice. But in true Nigerian fashion, I believe we're pushing through it and making it work. Thank you. Thank you.
Okay, that was really interesting.
Yes.
So it's time to turn it back to the audience. Please head over to the polls and vote, and let's see how you decide.
Okay, and the last but certainly not the least topic up for debate today is pay cuts in a COVID era, a necessary sacrifice by all, or an unfair burden on already underpaid lawyers. For the motion is Nii Emmanuel. Nii is a senior associate in the corporate practice of Stream Sowers and Con, and I know that he's ready to convince you guys that it just might be a necessary sacrifice that we all have to pay at this time. Tosin?
Speaking against that is Martha Ape of Broderick Bozimo and Co. And I have no doubt in my mind that she'll do her bit to convince you that a pay cut in this era with people who already have burdens is an additional burden. But I'll turn it over to you. So, Nii, Martha, you have the floor.
All right, over to you guys.
Thank you. Thank you very much. Thank you, moderators. My co-debater, Martha, ladies and gentlemen. It's an honor to speak with you this afternoon. We've had two days of pretty interesting conversations, very insightful conversations as well. And I'm pretty sure that your minds are full and there's a lot to chew on. My task today really is just to talk about, to speak for pay cuts in the COVID-19 era. Well, I know it's not necessarily a savory topic, but I trust that you'll be kind. The world generally is in a place that it has never been before, right? We are starting the year. Nigeria was supposed to grow by 2.9%, or the Nigerian economy was to grow by 2.9%. But here we are. The same experts who gave those projections are projecting now that the economy will contract between 3.4 to as high as 8.9%. If COVID-19 protracts, we are not seeing things getting back to normal until January 2022. The vaccine is not yet in place, and generally it's just uncharted waters. And this is the overarching theme in every conversation worldwide, and no less here at the NBA. You see, certain industries like aviation, hospitality, entertainment, all shut down. Production lines have been distorted. So my point essentially is that we're in a place where, the mantra for everybody is just to survive, right? We are not looking to make profits. We are not looking to thrive. It's really just to survive 2020. I guess the person who came up with the saying that hindsight is 2020 is probably biting his nails at this point, So you may ask, how does all of this affect lawyers like us, and how does it affect the MBA? And the point is that we service these industries, right? Our clients are in all these sectors that have been affected by COVID-19. And they're working with tighter budgets or no budget at all. And in effect, we also are not getting as much work as we would have gotten if things were normal. And so the question I'm asking is, is it such a terrible burden for you to take a pay cut for your firm or your company to survive between now and when all of this is behind us? Or would you rather that some of your colleagues were fired so that you could maintain your own pay, or that you lose your job, in order for your firm to be able to pay or maintain the pay for some of the other staff? I think these are the points, or these are the options really when you stack them by each other. And the point really is a pay cut such a bad idea. I think it's a straightforward topic, a straightforward subject, and I sort of think that I'll close it at this point, because I think that it's straight to the point, and pardon me. Yeah, so it's straight to the point. Those are the major issues I'd like to just drive home at this point, because I mean, look at it during the lockdown, right? During the lockdown, we had, if you went towards the Lekki axis, you saw people who were lined up on the road, we're banking on the kindness of other human beings to feed them, and as a matter of fact, some of our lawyers, some of our senior lawyers helped settle funds to sustain and support younger lawyers who couldn't afford as a result of the lockdown of the courts and everything. And this is the realities we face. And if you're receiving a pay cut so that you could maintain yourself, maintain your family, your responsibilities are not reduced, I think that it's a fair burden. And I wouldn't even call it a burden, I'll call it a lifeline, really. I'll call it a lifeline, because just for you to sustain yourself between now. All right, thank you very much.
Good day, ladies and gentlemen. I'll be arguing on the topic, pay cuts in the COVID era is not a necessary sacrifice by all, but an unfair burden on already underpaid lawyers. But before I proceed, I'd like to define some key terms. According to the Black's Law Dictionary, the word necessary connotes something that is essential, useful, or convenient. The word unfair means something that is not practicable in a business dealing. Having defined this concept, I would like to ask, is it convenient to cut pay of already underpaid lawyers? Is it convenient to cut pay during a pandemic? My answer to these questions is no. Nigerian lawyers are already underpaid. They earn as low as 30,000 naira, 20,000 naira. Yet here we are debating further cutting their salaries. Now, most of the employers affected by the pandemic are those who can continue paying their workers and those who would not be able to pay their workers. All a pointer to how serious their businesses are. First, it's important to consider the welfare of workers at this time. Most of these lawyers have had to adjust their life patterns to working from home. They're having to make the extra sacrifice of avoiding distractions from their families, friends, and even neighbors who they are locked down with. Not only that, there is the constant anxiety of trying to keep safe and not knowing what will happen next. If you ask me, it is only wise for employers to increase the salaries of their workers at this time, or at the least provide welfare materials. In my office, for instance, provisions were made for internet connectivity and even transportation so people can pay for their Uber or fuel their cars. At the end of the day, this is a benefit to the law firms who would have more productive work by its workers. An organization or a law firm that has to choose between sustaining itself or sacrificing the welfare of its employers has no business being an employer of labor and is better off functioning as a sole proprietorship. As a matter of fact, the hallmark of a good business is not only to be able to pay for the worker's salary during the good times, but also on rainy days. Furthermore, the pandemic has brought about ease of doing business through digital technology, thereby putting more money in the hands of employers. Over the years, we have had law firms pay a lot of money for physical activities like organizing meetings and conferences, paying for plane tickets to travel all over the world and across the country to carry out their brief. But with apps like Zoom, Microsoft Teams, Upin, and many others, meetings can now be carried out online. We even had, in the past couple of months, trials and judgments delivered via Zoom. While more money has now been put in the hands of employers, thereby taking the excuse of being unable to pay salaries, employees, on the other hand, now have new sets of responsibilities and challenges, both economically and financially. They not only have to cater for their own needs, but those of their loved ones and their families. Besides that, they have now to figure out how to get electricity, internet connectivity, and even convenient workspaces. Some of these lawyers earn so low that they live in places that are not befitting for human beings. Talk more of lawyers. So, picture an underpaid lawyer. Let's say he earns 30,000. Let's raise it to 40,000 naira. He has to work from his tiny room in Maraba, where the only properties he probably has are his small camp-size bed, a camp-size gas cooker, and a generator. This same person has to work from that tiny bed without backache. He is most likely going to squat, kneel, or even prostrate to be able to get any work done. He still has to fuel his generator and also think of internet connectivity. In what universe is it realistic, useful, or convenient to cut the pay of such a person? Not in this universe. Perhaps in a utopia or an alternate universe. It is like fitting a person into a tiny space and asking him to walk right through the wall. It is impossible. And similarly, a lawyer is better off without a job than having to have his already poor remuneration cut. Thank you very much.
All right, thank you very much, ladies and gentlemen. I would sort of take on the point made by my co-debater Martha, given the example of the lawyer who's stuck in Maraba in a small corner with a 30,000 naira a month salary. My point is, I think my response to that is, what's the option? She says he's better off without a job than having a pay cut. And the question, and then the option she's putting before him, more or less, is saying that he should go without any pay, go without certain income at the end of the month, even if it's discounted from what he earned before. I think that sort of just that sort of supports my position in the sense that even if you're taking a peak, right? Even if you have to sort of cut down on your expenses and essentially cut your maybe penny pinch a bit. Is that such a bad sacrifice as opposed to going without pay? Would Martha prefer for this gentleman to go to the street and beg? Would she prefer for him to be a burden to his family as opposed to having, maybe if he took a pay cut of 50% and earns 15,000, right? Is that not better than having to go with no expected income at the end of the month? And just for the period of COVID-19, hopefully we see the end of it. And that's my point. I speak to the point. I also like to just raise the point that, or the fact that lawyers are being underpaid. And my point is, many times these law firms, you can't give what you don't have, right? And we just assume that many times, many law firms. Thank you. Thank you.
Thank you very much, Lee. You've kind of made this debate very easy. Now, the fact that lawyers have to choose between the devil and the deep blue sea is the unfairness that this topic seeks to address. As a matter of fact, many people practice law because they enjoy it and they have a passion for it. It's not that if today someone loses his job, there are no options. But we are lawyers, we chose this profession, and as such, we should be adequately remunerated. The fact that an organization has to choose between putting its employers out there or getting them paid shows that, as a matter of fact, that business, that organization or law firm has no business being an employer of labor. Law firms should be able to prepare in advance for salaries of their employees. There are days when clients would not come. There are days when there will be no cases. How will this law firm be able to pay for its employers? If a company or a law firm cannot boast of being able to pay for its employees at all times, then it should think of being a sole proprietorship. But as long as you have decided to run your organization, you should be able to pay for your workers. Now, you're saying that working from home takes away certain expenses, which is true. But the fact that certain expenses, such as transportation, no more exist, do not in any way take out new expenses that arise, such as electricity, like I mentioned, and internet. These things cost tons of money, and lawyers already earn too little to be able to provide for them. As such, law firms, organizations should not cut salaries of their employees during a pandemic. The point is, this is not the time for such. I hope with this, law firms will see the need to remunerate their employees better, because lawyers, as a matter of fact, deserve better. Thank you.
Martha.
So that was really great. And well done to you guys. Well done to everyone. So for the last topic, can the audience please start to vote? I know that people have been voting for the other topics. So what we're going to do right now is to take a short break. We'll be right back whilst the results are being collated.
Thank you very much.
Thank you.
Everyone, welcome back. Thank you again for joining us.
Thank you for your patience.
Thank you. The moment of truth has arrived, and we will now be announcing the results for the debate session. Okay, the first topic is digital technology, an aid or inhibitor of legal practice. The winner is digital technology is an aid. So Omomi wins.
By how much?
By 94%. That's very high.
Okay.
Okay, and the second debate, that is, are 9 to 5 work patterns still relevant? Abolanle wins by 69%. Seems like the girls are taking this one. Oh. What's happening? Okay.
Right, the third topic, are Nigerian trained lawyers well equipped for practice in the digital age? Winning by 80% is Tolani. Nigerian trained lawyers are ill-equipped. For the girls, give it up for the girls. The girls are leading. And the last topic, the very last topic, pay cuts in a COVID era, a necessary sacrifice by all or an unfair burden on already underpaid lawyers. Your guess is as good as mine. Of course, winning by 60%, pay cuts as a result of COVID-19 are an unfair burden. Martha took this one. So congrats.
So
congrats to all the ladies. Well done, well done.
All right, I don't know whether to run to hide now, but okay, we just have to, I'm just going to walk through this final moment.
It's a clean sweep, a landslide. Like there was really nothing else for the guys to hold on
yeah,
to.
We hear you. Stop
well done, ladies. Well done, very well done.
All right, we'd just like to say thank you very much to the NBA SBL for this opportunity. Thank our debaters as well for all their hard work in putting all their arguments together. And Tosin?
Thank you to the audience for listening, for watching, and for voting. Thank you very much. And a very big thank you to all our sponsors who have made all of this possible. Thank you.
Thank you very much. Good afternoon.